Good afternoon, ladies and gentlemen. Welcome to Civil Justice Subcommittee for Tuesday, February 27th, 2024. Madam Clerk, please call the roll.
Good afternoon. Representatives Bolso, Capley, Eldridge, Farmer, Grills. Are you here, Representative Grills? Lambert, Parkinson, Todd, Chairman Russell.
Here.
Chairman, you have a quorum.
Thank you, Madam Clerk. Any personal orders, members? Personal orders. All right, seeing no personal orders, just as a reminder, if you vote in opposition and wish to have your vote recorded as such, please check in with TJ and she'll record it. So thank you for that. We got a couple of house cleaning items here. Item number 1, House Bill 2919, rode 3 weeks without objection. Item number 7, House Bill 2809, rode to the March 19th calendar without objection. And item number 12, House Bill 2061, rode 1 week without objection. Chairman Farmer, you're recognized.
Yeah, Mr. Chair, I had a request for the committee without objection. If we can take item 6 out of order and pull it up. Chairman Halsey has several other bills he's running, just as we all are. I was going to see if we could take him out of order.
Absolutely. That brings us to item number 6, House Bill 2806 by Chairman Halsey. We got a motion and a second, and I do show an amendment, Chairman Halsey. What number do you show?
Thank you so much. I
Good to have
appreciate
you
your
here.
indulgence.
Absolutely. What amendment number do you show? And we'll put that on the bill.
Let me get the right one for you. I'm showing 014435.
That's exactly what I showed. Does it make the bill?
It does, sir.
All right, members, do we have a motion and a second on the amendment? We got a motion and a second. No, we're voting to add 014435 to House Bill 2806. All those in favor signify by saying aye. Opposed, no. The ayes prevail. It's on the bill, and you're recognized, Chairman Halsey.
Thank you, Mr. Chairman. And again, thank you, committee, for your indulgence. I have today with me a lady named Betty Grand. She is out of North Dakota. She was with the Heartland Institute. She was a state legislator for 17 years in the state of North Dakota. And Heartland and their lawyers actually wrote this bill. And I will explain to you what it deals with. And then if you'll indulge me and let her speak. I did not know about these kinds of issues till recently. But in 1994, the Universal Commercial Code changed their wording in dealing with stocks and bonds. And it used to be, if you bought stock, you had a certificate that said you owned 100 shares of stock. That's all gone away. Now you're called an entitlement holder. And what most people don't realize, if you've read this book called The Great Taking, which is making its way across the country and scaring people, if you own stock or bonds and you're a broker and you purchase it through them and they now either sell or upline, or now they use your stock as collateral to borrow money. Well, what happens is if they borrow from some of the big banks like Chase or Morgan or some of the big boys, they use your stock as collateral to get their loan. If your broker goes belly up and goes bankrupt, those big banks now have access and can take your finances. They can take your assets away from you. Now, that sounds bizarre, but in 2008, the Lehman Brothers went under. And that's exactly what happened. The big banks took all the assets of folks who did not know they were on the hook for collateral for loans and cleaned them out. They had to file a suit in the state of Rhode Island to try and get their assets back. And in that lawsuit, the bank cited I mean, the judge sided with the big banks because of the wording in the UCC code. So what this bill does is, it is an attempt to keep that from happening to Tennessee people who have investments in stocks and bonds. And it also, the bill does two things. It tries to prevent that from happening, but it does a second thing, and it says in any pending lawsuit that's dealing with this, you don't have to go to Rhode Island. The jurisdiction will be here in the state of Tennessee, where the stock owner or the entitlement holder, as it's called now, resides. So that's the gist of the bill. And if you would indulge me and go out of session and listen to Mrs. Grand.
Thank you, and very good explanation. Members, without objection, we'll go out of session to hear from the untimely filed witness. Ms. Grande, you're recognized. You'll have 3 minutes.
Thank you very much.
Thank you. And if you'll just state your name and title and everything.
My name is Betty Grandy. I work with, and I do work with Heartland on other issues, but not this particular one. I work with Pro Family Legislative Network on this particular issue. This current law was, the representative did an awesome job explaining this. And really this came to our attorneys as an issue back in end of November, December, as a very critical issue of the taking of property. And now you might go, well, you're talking stocks and bonds. In the UCC code, of which this is the part of, they consider it property. And that's where it becomes a taking of that property. So I just want to kind of explain that first up so that it's understood. And really, I think Mr. Chairman, the representative did a great job, and it might be easier if you guys just ask me questions.
Very well. Members, we got any questions for Leader Lambert?
Someone who hasn't handled this before, what exactly do you, when you say it's a taking, what is being taken, what's the process is being taken, and what is the loss that is being incurred?
Great.
And you two are welcome to go back and forth.
Thank you, Mr. Chairman. Representative, what is being taken is, let's say you wanted to invest in Microsoft and you bought 100 shares of Microsoft with your broker. And in the old days, in the good old times where you would think that you now had 100 shares, you don't. You have an entitlement to that. So that broker, then he needs assets and money, so he goes up to the next level and he borrows or he trades in that level. He's trading off of your entitlement. Then the bigger bank up on top, who is funding and taking care of these things, has a hold as an asset to that broker. So let's say someplace in this chain, there's a default, like the example of the Lehman. So there is this default. Your property, your shares have now been lent out as a bonding to that loan, and that bank steps in as first receiver. Okay, you think of it in that bankruptcy lineup. They come in front of you on your property. So they've taken your property. This bill lines you up as number one receiver before everybody else because it's your entitlement property. It's your shares. And that got mixed up in the code a number of years ago. And it wasn't really recognized as that type of thing because everybody was kind of dealing with that Lehman's thing and how do we save the too big to fails and that type of thing. So this is to protect the consumer over the too big to fail. Does that make sense?
It does, and Chairman, thanks. Let's go back. But I mean, this is a contractual obligation that is laid out when you use a broker to purchase those shares. I mean, obviously you can become a shareholder, you can purchase shares directly. You don't have to go through a broker, correct?
Correct. You don't have to. Most people go through some type of a broker, and think of it on the lines of your state pension plan. I believe you guys have it. You're not an independent pension plan, right? The state runs the pension plan.
We have a hybrid, but
Yeah,
there is
okay.
an old defined benefits program that's
okay.
out there. So the defined benefits plan is probably what you're, yes, ma'am.
Yep, thank you. And so they, that's property that ends up out trading. Your investment group is not taking care of that. They turn that over to these groups to do that, and it gets mixed around and shared around. Now, this has been more directed at the individuals, but at the grand scheme of things, in a big fallout, the pension plans will take the hit as well because they're being held and traded up. In that contractual side that you're talking about, what's happened is the brokers, especially those that we've talked to about this, have said they were unaware that it became a collateral to what was going on. And so this would be that correction to that.
Interesting. Thank you.
Mhm.
Thank you. And Representative Grills, you're recognized.
Thank you, Mr. Chairman. And just for point of clarification, a while ago you said something about the good old days. When is that time frame from when it used to be that way? What was that defining moment? What law was it that changed?
This law came onto your books in around 1994. And so it was in that time frame that the banking industries were looking at how do we shore up and hold ourselves harmless in this time frame of ups and downs in the markets.
What was
You two are free to go back.
what was the reason for that though at that time? And I'm
There's no explanation in the UCC's minutes as to why they wanted to do this in that time frame. So the ULC sits down and writes, okay, so the ULC is the, now I just went blank. Uniform Law Commission was formed like in 1890 something. And they were trying to set up uniform laws across the country so that you can have business dealings, and things like that. And so this uniform commercial code was then developed. And over the course of time, it has expanded and expanded and expanded because they're trying to keep up with the times. Typically, the UCC would never offer in big changes until about 10 years into the process because they're moving slow and deliberate. But you guys would have seen this last session when there was I think it was about 170-page UCC bill that came in front of you, and it ended up having to be, I think you called it, tabled it. And it has come back in another form for this session, and I haven't followed that particular bill. But they had gone in and they were talking about the cryptocurrencies and some of that type of marketing and changing the definition of money and how those types of things would work. And that's when that concern of the CBDC came up and things. So the UCC has moved into a wider branch of things that across the country we weren't quite ready for. Typically, and as a former legislator, I will admit this, those bills come in and they're very, very big, they're very technical, and they're very difficult to read. And so you rely solely on the attorney that comes and tells you, this is good stuff, we need it, pass it.
Sure.
And so that's what happened is this was a good bill, we need this, so just pass it. And that happens. It happens all across the country because all of the states have this in their books. They're not as uniform as the Uniform Commercial Code wants to claim it is, because even in their own writings, they talk about the uniformity of the commercial code. Each state does business differently, so things meld differently. And as these things develop, they try to bring these things forward. These have been a couple of missteps. People are trying to catch up with them. And now we're looking at trying to readdress where the Uniform Commercial Code overstepped or went in a direction that probably was not their preview.
Thank you for being here.
Representative Bullseye, you're recognized.
Thank you, Mr. Chairman, and good afternoon, Ms. Grundy. I'm having trouble understanding the purpose of this proposed legislation. My understanding is that typically when you have a Tennessean who invests, You're dealing first with an investment advisor who's licensed by the Securities and Exchange Commission under the Investment Advisors Act of 1940, or you may be dealing with a broker-dealer, of which you have two flavors, introducing broker-dealers and custodian broker-dealers that are licensed by FINRA, the Financial Regulatory Agency, under the Investment Company Act of 1940. And so typically, if you go to an investment advisor who's a fiduciary, you make an investment, it's going to be held by a custodian, such as Charles Schwab or Merrill Lynch or UBS or Raymond James. And the broker himself doesn't even have custody of the assets to hypothecate them or to pledge them as collateral in the example that you've given us. And even in a case where a broker might do something of that nature, we have anti-fraud provisions under both the Securities Act of 1933, Section 12A2, and we also have anti-fraud provisions under the Securities Exchange Act of 1934 under Rule 10B, Section 10B and Rule 10B5 thereunder. So I'm having difficulty understanding exactly how, in the typical financial environment we have, where we've got FINRA, the SEC, regulating heavily investment advisors, introducing broker-dealers and custodian of assets, that something of this nature is necessary. Could you address that?
Certainly, I will try to do so, Mr. Chairman and Representative. In the current way of things are done, you don't own shares anymore. You own an entitlement security. And that's where that breakdown starts to come in. And so if you were to look at the current law, it sounds like it would be all just fine, to the extent necessary for the securities intermediary, the people you were talking about, the intermediaries there, to satisfy all the securities entitlements with respect to the particular financial assets, all the interest in that financial asset held by the securities intermediary are held by the securities intermediary for the entitlement holder. So they're holding it for you, and are not property of the securities intermediary, just as you said, and are not subject to claims for creditors of security intermediaries. So that's where we think it is. Problem is, there's except. And under except, that securities intermediary has it as, I hate to read the bill part to you. That's the tough part is with your guys' way you draft bills, you just kind of strike them out so you guys don't get to see what's struck out. So that's what I'm kind of addressing so that you can understand that. So if a securities intermediary does not have a sufficient interest in a particular financial asset to satisfy both its obligation to entitlement holders who have security entitlements to the financial asset and its obligation to the creditor of the securities intermediary who has the security interest in the financial asset, the claims of the entitlement holder other than the creditor have priority over the claim of the creditor. And that continues on in another section, again, with except, and it goes into that there's claims, the creditor has claims over it before you. And so that's where those exceptions in there. So in the bill, section 2 and 3, that's where those are struck out so that you as the entitlement holder hold first place.
Let me, Mr. Chairman, if I might, I mean, you stated, Ms. Grandy, that you don't actually own the shares. I mean, if I have an investment advisor that purchases shares in IBM or Microsoft or Apple for me, I do own those shares. They're in my account. So when you say I don't own those shares in my investment account, I'm not sure I understand that, because the shares are held in street name so that they can be easily traded on our securities markets. But every person who is an investor by law is going to be getting a statement on a monthly basis or a quarterly basis that shows the securities, stocks, bonds, other types of debt instruments, treasuries that are in their account. So when you say that you don't own those shares, I mean, respectfully, I do not believe that's true.
Well, it's in that You have purchased them and he has them for you, but he has traded them up. Okay, so yes, eventually you can get them back. Just like when you go to the bank and you put $1,000 deposit into the bank, when you sign that deposit slip, it says you can't have this back right away because it's theirs once you give it to them. Okay, and so that's kind of that same thing with these shares. They're yours, but we don't have the paper shares anymore, right? You used to be able to go in and you bought it and you held your bond, you held your shares, you knew what you had. And now when you do that, it becomes an entitlement investment. And that's where this terminology gets a little confusing, because now you just have you're entitled to it, but you're not entitled to it in the proper order.
If I, just two final questions, Mr. Chairman. First, are you aware of any occasions where any Tennessee investor has been harmed by this practice that you're discussing, where a broker of some type pledges the investor's assets as securities? And then secondly, if you are, isn't it true that such an investor already has an adequate remedy under both the Tennessee Securities Act of 1980, under the Securities Exchange Act of 1934, Section 10B, and under the Investment Advisors Act of 1940?
And with those investor acts, I cannot address those exactly, but yes, there would be, they would be the protection. And currently there is some protection, and there's actually supposed to be insurance that these brokers and stuff have. The insurance has been basically oversold, or it's not funded well. But right now, I mean, we've been sitting on this for quite a few years. This law has been on the books for quite a while, and there hasn't been a big blow up. But we've also seen in the most recent years a lot of ups and downs and back and forth. It's a ticking time bomb of how is this going to be addressed in the next blow up? Whether it is in this industry here or in a financial industry, but it's that volatility that brings this to the forefront that, we should put in the books that the Tennessean comes first, and then the rest can come in line on that breakdown.
Thank you, Mr. Chairman. Thank you, Ms. Grandy.
Thank you. Any other members have any questions? If not, I've got a couple. Do you know if any other states has passed any kind of legislation like this?
This was just put together at the first of the year. South Dakota ran it. That bill did not make it out of the committee. They do things a little different than what I'm used to, but the committee just chose not to bring it forward. And but the hearing that I saw online, I thought went well. It was very well understood. But they were the first. We know of a couple other states that are drafting this at this time, but I have not heard that they have bill numbers yet.
Okay, so we would be the first state.
Absolutely, of which is a benefit to you, because it allows for people to want to be here, do investment, do business here, because it is far more business friendly.
Are there any federal laws related to this?
No, the UCC is all done at the state level.
And how will this affect foreign investors? Do they have any type of issues with this?
There are a lot of foreign there are a number of countries that have implemented similar legislation to what's currently on the books, but there are some of those countries that are in the process of turning it back around.
And if somebody takes another person's shares of stocks, would that not be considered theft?
Yes. And then you address section 1, 2, and 3 of the bill in the jurisdiction of the lawsuit.
Thank you. Representative Parkinson, you're recognized.
Thank you, Mr. Chair, and thank you for being able to break this down in digestible form. And I just want to touch on So when we purchase these stocks, so we're entitled to those. If I buy 100 shares of NVIDIA, which I wish I could right now. So when I make that purchase, I'm entitled to that purchase that I made, but somebody else is actually holding that property. And that's what you were explaining earlier. Am I correct to my colleague?
Yes.
Right. And so, and then if for whatever reason, there's a default or the creditors come looking for their money from that entity that's holding my shares, then right now, because this law is not in place, they could use that as part of the payback to that entity that's coming to collect.
Awesome.
Which, thank you. Now, awesome to you. Kudos to you for being able to, make it digestible and visual for me. And so, which would leave the person that made the purchase, they would be the loser. Kind of reminds me of the music business. The artist is the last to get paid, right? And this would, in turn, move the artist up so that and protect them from their purchase becoming a loss because the person that's holding the property messed up. Am I correct in that assumption? Okay.
Yes.
Thank you for that. I appreciate it. Thank you.
And when this started to come out in South Dakota, it really took up a lot of press. And so nationwide, we've been hearing from various brokers who have said, do I need to have my investors sign off to know that this is what's happening? And so there has been some interesting conversation going on with that as well, because they don't want to be seen as having done something illegal like that.
Thank you, Mr. Chair. And to your analogy about the bank, we go in, we make a deposit, and we literally hand our money over to the banks. The banks then use that money to make money, our money, to make money, and that is why you hear why there's such a hard push against when we get into those depression spaces, why in the media you're hearing, don't take your money out of the bank, don't take your money out of the bank, because your money is not actually there, because the holder of that note doesn't have your money either. It's tied up somewhere else also. Am I correct?
Correct.
And if this same legislation would work in the banking space too, I think it would be good also to make sure that those of us that have our entitlements in the bank would be protected. Well, I guess that's what the FDIC is for, but in the same space. Am I correct?
Yes.
Thank you for
It
that.
always reminds me of, and I always have to see this in simple forms, and I use analogies of what I can relate to in my simple mind. And as I was looking at this and reviewing things, It's a Wonderful Life kept coming to mind. There's the run on the bank. Tom wants his money. Tom, I can't give you that money. Your money's tied up in Joe's house so that's what you were saying.
Thank you for that. Thank you so much.
Thank you. We don't have any other members with questions. Thank you for being here, Ms.
Thank you.
Grande. We appreciate it. We'll go back in session. And the sponsor, you're recognized.
Well, I can't explain it any better and sure can answer your questions.
So
that the whole effort here, by the way, I'm not alone. I think Chairman Zachary is running section 12 in this same code. This is section 8. The desire is just to protect Tennessee people. And that's the whole motive and that's the whole reason. So,
Representative Parkinson, you're recognized.
Thank you, Mr. Chair. And Chairman Halsey, I want to thank you for bringing the bill. I had no idea. I hadn't read this bill yet. But I thank you for bringing the bill, and I actually want to sign on to it. And thank you for bringing the guest to explain it too, because she did a great job of explaining it. I think this is good, and I think it's important that we protect the investments of our citizens, you know, and make sure that they get theirs back first in the event that something catastrophic happens. And we know that that is a great possibility. So thank you so much. Appreciate it.
Thank you.
And Chairman, would you have a problem, since we've got a lot of questions, if we roll it for 2 weeks and look at it around March the 9th, I think that is. I'm sorry, March the 12th. I couldn't count today.
I'm at the will of the committee.
Without objection, roll 2 weeks.
Thank you.
Thank you.
Thanks for working me in the front end too.
We're glad to have you. All right, that brings us to item number 3, House Bill 2113. We're taking this one out of order. Representative Powers, you are recognized. We have a motion and a second, and I do not show any amendments.
That's right. Thank you, Mr. Chairman. This is a good bill. We need this. We need to pass it. I think that's what. Okay, House Bill 2113 is an anti-class action bill that makes Tennessee law consistent with federal law. The legislation would shorten the statute of limitations for claims for unpaid wages, for hours worked, overtime, minimum wage, and salary, bonuses, commissions, and other compensation owed to an employee or an independent contractor. The maximum statute of limitations right now under the Fair Labor Standards Act, or FLSA, is 3 years. This bill simply shortens the statute of limitations for those claims from 6 years to 3 years to make Tennessee law congruent with the statute of limitations under the FSLA. And with that, Mr. Chairman, I renew my motion.
Thank you, Representative Parkinson. You're recognized.
Now that one, I can't roll with you on this one. But why would, and I'm just asking, why would we reduce the amount of time that if a person has not received their wages that they should have received, why would we reduce the amount of time for them to go back and get them?
Well, we're going back 3 years. We're just matching up with what federal law is right now, because when you go back for 6 years, you get a lot of class action suits from employees going back based on the current statute or a breach of contract. So it just shortens that length to make it 6 years is actually too long. 3 years gives them plenty of time. Plus, they have up to 3 years to file that claim.
Y'all are free to go
Okay.
back and forth.
Thank you, Mr. Chair, and thank you, Chairman. But had the employees paid the people what they were supposed to pay the people, there probably wouldn't be any suits to go back to after 6 years. Am I correct?
Mr. Chairman, yes, after you give somebody, everybody, we need a period of time to where it can be, you couldn't do it indefinitely. You got to have some type of framework to where they can go back. And that's why we're going back with the 3 years to make it the same as the federal government. That's what the federal government is doing right now.
Okay, thank you, Mr. Chair.
Thank you. Leader Lambert, you're recognized.
Thank you, Mr. Chairman. Chairman, I dropped off a sign-on sheet down there. A couple of us decided to sign on to your bill based on the description and what's included within the language. Thank you.
All right, thank you.
Thank you. Chairman Todd, you're recognized.
Thank you, Mr. Chairman, and I do as well support this. I think this is a good idea to have some parity with federal law, and certainly 3 years is plenty of time for folks to see a problem and get it corrected, at least get it filed. So I think that's certainly adequate. Thank you.
All right, thank you. Yeah, and this, just to mention one thing, Mr. Chairman, the Tennessee Chamber of Commerce, NFIB, Tennessee Fuel and Convenience Association, Greater Chapter of Associated Builders and Contractors, Hospitality Tennessee, all these groups are for this bill and support it. So that's another reason I'm bringing it forward.
Very good. Representative Parkinson.
Thank you, Mr. Chair. I just want to comment. I'm just shocked at all of this support for the federal government that we're getting in here. But thank you, Mr. Chair.
Let me withdraw that.
Move previous question.
All right, the previous question's been called, and we're voting to send House Bill 2113 to civil pool. All those in favor signify by saying aye. Aye. Opposed, no. Ayes prevail. Civil full.
Thank you,
Congratulations.
Mr. Chairman. Thank you, committee.
That brings us to item number 2, House Bill 2120 by Chairman Faison. We do have a motion and a second, and we've got an amendment. If you'd like to
Yes, sir.
give me your amendment number, we'll check it here.
Yes, sir. We do have an amendment, drafting code 13928.
Okay, that's what I show, 013928. And it was adopted last week. Let me check see if we need another vote on this. Okay, you're recognized.
We're traveling with the amendment.
Yes, sir.
Thank you. Ladies and gentlemen, Mr. Chairman, good to be with y'all again. This bill is a bill that seeks to take out recreational purposes out of public use for eminent domain. Right now, Tennessee, we have a standard when a municipality decides to use eminent domain, and for the purposes, they can do it for all type of transportation and infrastructure. And this is just a simple bill to take out that you won't be able to use eminent domain for recreational use.
All right, members, you heard the explanation. We got any questions? Chairman Todd.
Thank you. Can you tell me what the amendment is actually changing?
Y'all welcome to go back and forth.
Okay. Thank you, Mr. Chair. Mr. Chair, this is an amendment that worked with TDEC to make sure that we protect brownfields and state parks.
Okay, thank you so much.
All right, members, any other questions? Seeing none, we got the question on the bill. We're voting to send House Bill 2120 to Civil Full. All those in favor signify by saying aye. Opposed, no. The ayes prevail. Civil
Thank you.
Full, congratulations. Brings us to item number 4, House Bill 2066 by Chairman Clemens. We have a motion. We got a motion. Do we have a second?
I was going to roll this bill 1 week, so I'm waiting on an amendment from the Bar Association. If we can get a second.
We still need a second. No second.
Second.
And all right. Without objection, rolled 1 week.
Thank you.
All right. Item number 5, House Bill 2746 by Chairman Clemens. We got a motion. We got a motion. We have a second. Second going twice. Failed. Second, like a second.
Thank you, Mr. Chairman.
Brings us to item number 8, House Bill 2216 by Chairman Whitson. Chairman Whitson, you're recognized, and I show 2 amendments. And I'm showing 2 amendments. Which one, or would you like to roll both? Run
Mr.
both?
Chairman, the amendment we have, drafting code 014336 is the one we need to put on this bill.
Okay, members, we got amendment 014336. Do I have a motion on the amendment? We got a motion, and do we have a second? We got a second. Does it make the bill?
What this amendment names the bill, Daniel's law, and changes the effective date to be as soon as the legislation becomes law.
Great. Members, let's vote to add 014336 to House Bill 2216. All those in favor signify by saying aye. Noes signify by saying no, and the ayes prevail. Amendment 014336 added to 2216. You're recognized on the bill as amended.
Thank you, Mr. Chairman and committee. This legislation was brought to me by the Sexual Assault Center due to a young lady who experienced an assault and came to the Assault Center for help. Currently in statute, a person has 1 year to pursue civil action for a sexual assault, but has 3 years for criminal charges. This legislation seeks to align the civil statute with the criminal statute. This bill will update the statute of limitations for civil sexual assault cases to be 3 years without a police report and 5 years with a police report. This allows survivors to have time to process the trauma and navigate the legal process. This bill only impacts those who are 18 years or older. There have been cases where rape kits have not been processed within a year of the assault occurring, leaving survivors with no option to pursue civil action. For instance, Alabama gives 2 years for sexual assaults and no time limit for rape. Arkansas gives 3 years for sexual assault and 15 years for rape. Kentucky gives 10 years for sexual assault and rape, and Georgia gives 4 years for sexual assault or rape. We earlier provided a letter of support from the Joyful Heart Foundation, a national organization with a mission to heal, educate, and empower survivors of sexual assault. Mr. Chairman Committee, I have a survivor here, Danielle, and and also a civil attorney, Haley Baker, who would like to come and speak before the committee.
Thank you, sponsor. And we do have Danielle on the list, so we'll have her to come up if that's all right. Members, without objection, we'll go out of session and hear from Miss Danielle Powell. And Miss Powell, if you'll just identify yourself, make sure the light's on. As soon as you start talking, it'll give you 3 minutes here. So begin
Okay.
whenever you're ready.
Thank you so much. I'm Danielle Pyle. I am almost a lifelong Tennessean. I live in Davidson County, and in April of 2021, I was raped in my own home, in my own bedroom. I had been out that evening celebrating a friend's birthday when we returned to a neighbor's house. It was time for me to leave the party and walk home. So a man that was there that evening that I did not know decided he would walk me home. He walked me home 2 doors down. He proceeded to let himself into my house, where before I knew it, I was being sexually assaulted in my own home. 2 days later, I decided to file a formal police report after understanding what this life-changing event meant. MMPD came to my house, took my statement, and the investigation began. In June of 2021, the detective on my case gave all of my case information to the DA's office, including my rape kit, which I, to this day, almost 3 years later, do not know where it is or if it's ever been tested. When, in June of 21, when the detective handed everything to the DA's office, he said he would be back in touch with me as soon as he heard back from the DA. In May of 2022, I got a call from MMPD that told me that the DA's office had given their decision in September of 21, but my file was lost on a desk. In May of 2022, that puts my assault 13 months out. He went to tell me that I had a civil remedy in my case and then paused, realizing that it was past the 1-year statute of limitations. I do not have justice in my case. And that's what I'm here to ask you today, is to give survivors more time to process what's happened to them. It's too much in a short amount of time. And so I just ask that you extend the statute of limitations with respect to the 3 and 5 years.
Thank you, Ms. Powell. Any members have a question for Ms. Powell? Later, Lambert.
I know we visited in the office, but thank you. It is phenomenally brave for you to be able to come here and share one of the worst things that ever happened to anybody in front of a bunch of strangers that you don't know. And so you're very, very brave and strong young lady. It makes a difference that you share what happened with you so that it can help others down the road. And I know we talked a little bit about that in my office. I know I can't guarantee you this bill will help you in your case, but it will help lots of other folks. And so I just want to say thank you for your testimony. Gosh, I can't even imagine what it's like to sit there and just talk about this in front of all of us and just thank you. Okay.
I appreciate it. If I may, I just wanted to say that I appreciate those that met with me before. You know, I checked every box I was supposed to check in this process. I did everything I was supposed to do from A to Z, and the process still failed me. So let's not let it fail anyone else, please.
Thank you, Representative Grills.
Thank you, Mr. Chairman. And I too had a conversation in the office, and I thought about that conversation many times. I have 2 young daughters, and I can only imagine what your family is going through as well as what you're having to deal with on a daily basis. So my heart goes out to you and them. I'm kind of concerned about the police department. What happened there? I mean, did you file a complaint, about them letting you down? And if so, I'm just curious as to what answers they were giving you for being so lackadaisical, if you will.
They were just as responsive in my question to that as they were to my case.
I'm sorry?
They were not helpful. They didn't give me any answers.
Did you like file a formal complaint or
I did
anything?
not.
Okay.
I didn't know that was an option.
Well, I'm sorry that justice has let you down in so many different areas there. But just thanks for coming and making us aware of it. And I too agree with Leader Lambert about just the attitude that you're bringing this with. I appreciate you.
Thank you.
Representative Bolzo, did you have a question?
Not a question, Mr. Chairman. I just wanted to add my thanks to Danielle for coming forward. I mean, we met in my office, and you're an amazingly brave young woman who's come forward to help other victims with a law that really cannot help you yourself. So I just want to tell you from the bottom of my heart that it was a pleasure meeting you. I appreciate your coming forward and doing something that's going to help others in the future.
Thank you.
Thank you. And Ms. Powell, I appreciate you being here. And Danielle's law is going to change things in Tennessee when it passes. It's going to bring justice to others, and that's because of you. And the work that you're doing here is not going unnoticed. And I appreciate you and everything you've done, and you're making a difference. So thank you.
Thank you.
Members, without objection, we're going back in session. And sponsor, you're recognized.
Thank you, Mr. Chairman, and thank y'all for those comments. And you see why we named this Danielle's Law, because of her bravery to come forward and take the lead on trying to make sure those in the future are protected. Mr. Chairman, also, we submitted a request for a civil attorney who's litigated these cases, Haley Baker, to speak for a few moments to share her experience. Do you have her on the list?
We do not have her, but I'm pretty sure this will go to full committee. And if she can come back during full committee.
Okay. Thank you, Mr. Chairman.
Any
Again,
questions?
members, thank you for the respect that you had here today for Danielle. And with that, Mr. Chairman, I renew my motion.
Thank you. Any questions for the sponsor? The question's been called. We're voting to send House Bill 2216 to civil full. All those in favor signify by saying aye. Opposed, no. The ayes prevail. Congratulations, civil full. That brings us to item number 9, House Bill 2453 by Chairman Whitson. We got a motion and a second. Chairman Whitson, you are recognized, and I do show an amendment.
Yes, Mr. Chairman, I have an amendment. I show 013734.
Does it make the bill?
No, well, basically it does, yes. It shows
Okay.
It explains the bill, yeah.
Great. Well, all right, we got a motion and a second. We're voting to add 013734 to House Bill 2453. All those in favor signify by saying aye. Opposed, no. The ayes prevail. And Chairman Whitson, you're recognized on 2453 as amended.
Thank you, Mr. Chairman. This legislation comes out of my discussions with Covenant families and their experiences that they have had over with the legal process over the last year since the tragedy at Covenant School. This bill will allow citizens injured by criminal conduct the ability to file a cause of action for civil damages within 3 years rather than the current 2 years listed in the Tennessee Code annotated. It still requires criminal charges must be brought against any persons alleged to have caused or contributed to the injury and are subject to criminal prosecution by a law enforcement officer, district attorney, or grand jury. With that, Mr. Chairman, I renew my motion.
Thank you. Members, we got any questions for the sponsor? Seeing none, we are voting to send House Bill 2453 to civil full. All those in favor signify by saying aye. Opposed, no. The ayes prevail. Civil full. Congratulations.
Thank you, Mr. Chairman. Thank you, committee.
Thank you. That brings us to item number 10, House Bill 2267 by Chairman Boyd. We got a motion and a second. Chairman Boyd, you're recognized.
Thank you, Mr. Chairman, committee members. House Bill 2267 makes a couple of changes to the tail end of the eviction process, specifically the forcible entry and detainer. And just to clarify, if you guys don't know what that is, after the eviction period has lapsed, if someone, a former tenant or someone occupying a property refuses to leave, then a forcible entry and detainer would be obtained to take law enforcement out there to actually get them out of there. And what this bill does is it reduces the number of days from 15 to 7 that a general sessions judge may postpone a trial for forcible entry and detainer. And it also makes a change in the event that the defendant files an appeal and the general sessions judge would normally kick it out to a circuit court. What this would do is state law already requires that the defendant must post a bond to the clerk in the amount of 1 year's rent. And right now, that's not being done by the clerk. So oftentimes it'll go ahead and be kicked out there into circuit court. Months will go by before a court date just to realize that they never filed a bond, and then it gets thrown out anyways. This would require that if someone files an appeal, that they would have to demonstrate to the clerk that they have a bond in that amount. Mr. Chairman of the committee, I'll take any questions.
Very good explanation. And we do have a Leader Lambeth. Go ahead.
I was going to say, really good bill. Thank you. I mean, we seems like we do clean up and landlord tenant stuff every year. I think in most parts of the state, they are taking care of that issue. I think there's a couple of pockets where they're not. But I mean, if you're not paying your rent, you don't get to just freeload for an additional time because you appealed. I mean, you have to post that bond because it's somebody else's house that you are renting. And so it's not fair to force a landlord to just carry somebody without paying rent because they didn't pay rent. Eviction was filed, they went to court, the agreement had been ruptured, and then if they lose and it's clear they hadn't paid, that's there to protect landlords. And also, I'll be quite frank, I mean, in my community, these are not landlords that many times have 100 properties. It's folks that in their retirement might have 2 or 3 little rental places, and they need to get somebody else in there that's paying, because many times that's what's paying for their groceries. And so just appreciate the bill. It's a good, solid bill, and I had forgotten to sign on, but I will today.
Thank you, Leader Lambert, and Chairman Boyd, you're recognized.
Thank you, Mr. Chairman, and thank you, Leader Lambert, for those comments. I think oftentimes people think about the tenant, but they forget about the landlord, and they think about these mom and pop operations where people are still carrying a mortgage on a property. And unfortunately, there's no process like what we just described here for you to explain to your mortgage company, your bank, why you can't pay the mortgage because your tenant's not paying the rent. So I like this legislation.
Thank you. And you do have a witness, or is he just want to testify in case we have questions, or? All right, seeing no, okay, the question's been called. We're voting to send House Bill 2267 to civil full. All those in favor signify by saying aye. Opposed, no. The ayes prevail. Civil full.
Thank you, Chairman of the committee.
Thank you. Let's bring us to item number 11, House Bill 1822 by Representative Gillespie. And we will roll him to the hill without objection. We're going to take a short recess, so don't go anywhere. Stay tuned. All right, ladies and gentlemen, we're back in session. That brings us to item number 11, House Bill 1822 by Leader Lambert. So we got a motion and a second. Leader Lambert, you're recognized.
Thank you, Mr. Chairman. I stand ready for questions.
The question's been called. Now we're voting on House Bill 1822 to send to civil full. All those in favor signify by saying aye. Opposed, no. The ayes prevail. Civil full. Congratulations. All right, seeing no further business before us, without objection, we stand adjourned.